The resumption of the parliamentary inquiry into the suspended Public Protector Advocate Busisiwe Mkhwebane's fitness to hold office has been delayed again. The committee sent out a statement saying this is due to Advocate Mkhwebane's legal team not being ready. On Friday, members insisted that they will stick to the revised program that will see the hearing completed by the 28th of July. Friday's meeting came after a 2-month break because Advocate Mkhwebane no longer had legal representation. The suspended Public Protector terminated the mandate of Sianaho attorneys after the Office of the Public Protector said it could not fund Mkhwebane beyond the end of the financial year in March. After negotiations, funds were found and Advocate Mkhwebane appointed a new team of attorneys. On Friday, committee members raised concerns about the number of delays and vowed to stick to its latest program. National Assembly Speaker Nosiviwe Mapisa-Nqakula has also questioned the amount of time the committee is taking to complete its work. The committee will now resume on Wednesday. All right, let's talk further on this then. We are now joined by legal analyst Mpumelelo Zikalala. It's always a pleasure to see you, sir. Thank you so much for joining us here on SABC News.
Good evening to you and also good evening to your viewers.
All right, let's start here. I mean, if we look at how things are sort of playing out, are we likely to see this process sort of, wrapping up as soon as the 28th of July? Advocate Mkhwebane's new legal team is said to not be ready. I mean, what does this process look like, the process of them actually getting ready? I mean, one wonders if, 28th of July is too soon.
It may be too soon depending on the amount of work they need to do. Remember that the first thing they need to do is to appraise themselves as to the type of proceedings or where the proceedings are at the moment. That would usually mean reading the transcripts that have already been, or of the evidence that has already been delivered, the number of volumes of the information and documents they need to go through, and any other stuff in which they would need to research so that they are well prepared in terms of making those submissions, or even making an application to bring in or to recall a certain witness, or then to say, we need an extension. There are certain witnesses that we would like to bring, which will be able to understand or make the committee understand better the position of our client. So if all those things haven't been done and the amount of time has been allocated, it's simply impossible for them to prepare adequately. Definitely when they come back on the following day or the day in which it's been set by the committee, they would request a further postponement and be able to provide evidence of saying, we wanted to be ready as much as possible. However, due to circumstances beyond our control, we are not ready. And the information that we need to bring to the fore, it's important and it can't be missed.
Yeah, I see that these new attorneys have also briefed SC Mpofu, so he will then ultimately continue with representing Advocate Mkhwebane. Is that standard procedure, or how does that process sort of go? Is it a case of Advocate Mkhwebane herself saying, listen, I've got these new attorneys, but I would like you to continue with SC Mpofu as my representative there?
It is a negotiation process, one which depends on which counsel is client comfortable with. First, remember that we're dealing with a very important matter that pertains to the life of Advocate Mkhwebane. So she would then want to say, I want to rest assured or to be given an assurance that I want a person who's going to be able to represent me in a proper manner. And this is the individual in which I believe in. Now, for the attorneys which are on brief, it's not a simple matter of taking the information from one side to another in briefing advocates and both. It's also a matter of saying, we want to read the information which is there. We want to carry proper instructions so that when we are sitting there in the parliamentary process and the instructions are given to us, we're able to deal with them as soon as possible. So it's not a matter of simply being a bridge between the client and SC. We still have to apply our minds to it, but it's much better because we're dealing with an SC who's well acquainted with the facts, well acquainted with the matter, and is not going to waste any time going through the papers that have already been dealt with earlier.
Correct. And I mean, this might not be of consequence really, but I still want to talk about this matter and just, sort of touch on it. Of course, we got the news today that former Minister Tina Joemat-Pettersson has passed away. And as we know, her name sort of came into this issue in terms of her being fingered as one of the culprits who were soliciting some sort of bribe for a favorable outcome against Advocate Mkhwebane. The fact that she's now sadly passed on, Is this of any, significance to perhaps where Advocate Mkhwebane was going with this particular issue?
It would have a bearing in terms of the type of application that may come through. There are a number of them, by the way. The first one being another recusal application to those committees that are fingered in this particular report in the WhatsApp group allegation, in which then Advocate Mkhwebane has every right to then say, in my mind, I have a reasonable suspicion or reasonable apprehension that those individuals are not going to rule in my favor because I'm the one that has laid the complaint. So someone who's close to me has laid a complaint, and I don't think because I did not accede to their demands, they're going to rule in my favor, be able to think of this matter in an independent, unbiased manner. Can you please recuse them? And then I'll be able to continue. Now, if the application for recusal is then refused, you then have another High Court application that you can go to, and another extent in the delay in which will then have to take place. Secondly, is the numbers of the committee. Now, the next question would be, how many numbers are required for the committee to operate? Is the demise of the minister or the member of parliament would have anything to do with those numbers dwindling? Is there another person that needs to come on as part of this committee? If that's the case, how much time do they need to be well acquainted with the facts of the matter so that they're able to take a decision at a later stage?
Yeah.
So it's definitely going to have an impact, and it's something in which the chairperson must be thinking about as of tonight, but also wait for that application if it's going to come at a later stage. For those recusal applications, it may come due to the circumstances and the facts that have surfaced over the weekend.
Yeah. All right. So the inquiry then resumes on Wednesday. What are some of the pressing, I suppose one could say, outstanding matters that still sort of need to be ironed out? I mean, bearing in mind that this has been such a long, drawn out process and procedure. We've heard, from even, public protectors from other countries, for example. I mean, what more do we need to hear or see for the finalization of this process to actually take place?
Firstly, is the reassurance that the public protector is finished with the evidence. That's the most crucial one. Secondly, any other witness they should have to bring to the committee so that they're able to bring the evidence that is required will also go through that process. Now, the process is examination in chief, cross-examination, and re-examination if there is, and then it's final submissions in terms of both parties. I also think there might be a level of dispute on the number of things that took place when the public protector did not have a legal representative there. There might be an application to then say, strike out any information which was given to you as the committee in the disguise of you seeking legal advice or being advised or consulted on a committee which is there in Parliament. You must remember that the committee that is there, it is not there to advise Parliament. It is there to prosecute on behalf of Parliament, and Parliament are simply presiding officers. So you can't have them presenting any facts which cannot be disputed, presenting any documents or any information or evidence without the other party being there to raise any objections if they so wish. If you do that, it's a huge procedural fault that might cause you problems at a later stage. So those things may come up at a later stage.
Mr. Zikalala, many thanks to you. It's always a pleasure having you on the show. Thank you.
Thank you for hosting me.